again, attempting to get some insight from the court about your position, given what you said on the record last time about having attended Trooper Wolf's funeral and the comments you made last time on the record, which we've attached a transcript to this letter, in which you said you had no bias and that you don't know that he ever actually practiced or appeared before you in court, but you thought it was a matter of respect to attend the funeral. And then I wasn't aware at the time, quite candidly, the Detroit News article in which you were quoted as saying, I saw him, Trooper Wolf, in my court on cases he was involved with. He was respectful and kind to everyone. I just had a sentencing yesterday and a drunk driver he took off the street. I didn't know at the time you made those comments last time when we were discussing whether or not attending the funeral and all that was an issue that warranted recusal or disqualification. And we just raised the issue with you. And I did it, I thought, in a very polite way the last time, again, which was by letter, not seeking to recuse or disqualify, but to just ask for your input or reaction to it. And again, we took the same approach this time, which was, again, not with vitriol, to attempt to come in here and sort of, and castigate you. We were like, okay, we accepted your comments the last time we were here. Could you explain what now is a contradiction between your comments on the record and the comments in the Detroit News article? And the reason I raised this, and I raised it in the letter, and what I said was, look, I write to inquire further only because I wish to counsel my client effectively and to ensure that I can answer his questions to the best of my ability. And of course, one of the questions, of course, that a defendant in any case has, or in a criminal case has, and one of this magnitude, and one in which we think the decisions are important and could be very unpopular if Mr. Warren if the charges are dismissed, is whether or not Your Honor is the judge to sit on the case. That's a question that Mr. Warren, of course, has a right to ask of me, and I can't effectively advise him without being able to raise those issues with you. And again, I hope you can appreciate, and I hope you do recognize, out of respect for Trooper Wolf's family, for the state, for Mr. Warren and for his family, and quite candidly, out of respect for you, because I've known you for a very long time. Well, we're not personal friends, but I've known you for a long time. I wrote in this letter that I thought I wrote it in the most respectful way to attempt to raise the issue and give you an opportunity to, at least if you wanted to attempt to address what I thought was a contradiction.
All right, Mr. Hudson, do you have anything to say?
No, Your Honor, I think you explained it last time, and I know, well, maybe I do have something to say. I did receive a copy of Mr. Rockine's letter, and I think you answered the question. And I think even in his argument, I think he put forth something that goes to show that I don't think this is a problem. He indicates he's known you for a long time, has appeared here. I've appeared in front of you before, and whether or not you even remember now versus back then, whether Trooper Wolf actually appeared in front of your court, I don't think that shows any bias. I mean, you were very clear he works here. If in the article, if you indicated, maybe I saw him around, but by the time this case came around, obviously you did seem to remember. So I don't have any objection, because I think in this type of a situation and in this type of a profession, people do see each other. Mr. Rockine and I see each other. You see Mr. Rockine, and I think as long as you feel that you're not biased, and I believe you put that forth last time, I don't have any objection. I don't think that's a problem in this case.
All right, thank you. First of all, maybe I should clear some things up. I understand that you sent a letter, and I appreciate that. It was an ex parte communication, so the court did not read your letter. I was told, though, I was informed that a letter had been sent. My clerks informed me, so I did attempt to contact both parties by telephone so I could speak to both parties at the same time in regard to that.
That's not accurate, Judge. There was the first letter that was sent that had an incorrect fax number on it,
There was a subsequent letter that was resent. That is a matter, that is part of the court file. It was resent to both, we have facsimile proof. It was sent to the prosecutor's office on February 11th. The timestamp is 5/22. It was sent to the court on February 11th at 5:15. And we actually have a copy of the fax transmittal that was sent to the court as well. We received one return from the court, and I take very seriously the suggestion that I would ever attempt to communicate with any court ex parte.
Mr. Rockheim, you interrupted me, I let you speak.
Sure.
But a letter to the court is an ex parte communication, even though it was CC'd to the prosecutor. That's why I attempted to call both parties, so I could speak to both parties at the same time. But you were on vacation, so that is why the letter was sent back to you. I did not read the letter. However, I have a strong assumption, because I did read the news article wherein you were speaking to the press about the situation. So I do want to make it clear, though, that when I made my statement at the last hearing, this hearing, what I said was absolutely correct. My position does not change. On the day of the funeral, I actually assumed that you were making that motion because you had read that article. On the day of the funeral, I was involved in a conversation with Mr. Martindale, who is the reporter that you're speaking of. He did not seek me out. I did not seek him out. I was involved in a conversation with him and a number of other people. As part of the conversation, he asked me, did Trooper Wolf practice in front of you? My answer to him was the exact same answer I gave to you on the day of the hearing, the last hearing. My answer was, he did not practice in front of me personally. However, he has practiced in my court. Not meaning in front of me, but in this 52nd District Court. My answer was that, as far as I know, he was always polite and fair. It was then further asked as part of the conversation, I had indicated to him that there was an attorney that was before me the day prior in a sentencing. As part of the attorney's allocution, the attorney indicated that it was Trooper Wolf that had actually taken his defendant off the street, and his defendant appreciated that he had taken a drunk driver off the street. I was reiterating something that was told to me. That was what was reported. The entire conversation wasn't reported, but that was what the conversation was. It's the same thing that I said here. So I'm sorry that the entire conversation wasn't reported. I don't know that it was intended to be misleading. It's just that the entire conversation wasn't reported. So my position remains exactly the same. I went through the process to make a determination. Could I be fair in this case? My determination is yes, I can be fair, I can be unbiased, I can be unprejudiced. If I felt I couldn't, I would have recused myself. So it's the same. There's nothing different. Okay, so can we go forward, or is there any objection?
No, Judge,
I would know if there's been no motion.
I didn't, it's probably, I've been doing this for 23 years, and I have never shied away from a fight with the judge that I thought couldn't sit fairly. And I hope you will appreciate that I did not take that position with you. I merely asked for, in the most polite, if you didn't get to read the letter essentially said just that. The letter was written in a way that was the most respectful way that I could write to seek out what I thought was a contradiction.
Well, I appreciate
And it said, I have nothing but the highest respect for your Honor's integrity and professionalism. I have no doubt that there is a reasonable explanation for this apparent inconsistency. I write to inquire further only because I wish to counsel my client effectively.
Well,
I can't think of a better way for a lawyer to write a letter to a judge.
Well, I appreciate that. It wasn't brought to my attention through the letter. It was brought to my attention through the news article.
So, Judge, with that, you've explained it, and we will again take you at your word that, that when the tough call has to be made, that you're comfortable making it.
Thank you. Now, are there any other preliminary matters?
We did subpoena or ask the state to subpoena a civilian witness other than the civilian witness they intend to call.
Okay.
Mr. Hudson and I, out of courtesy to Mr. Poole, who will be that witness, have sought to have Mr. Poole called out of order so that he doesn't have to sit around and wait for Sergeant Lindstrom to testify through what we think will be a very long examination. Is that fair, Mr. Hudson?
Yes, Mr. Rockine did inquire as to that, and I thought that would be fair. Mr. Poole,